Hello, everyone. This is Annie Cartwright. I'm an attorney in Husch Blackwell's Higher Education Group. We're excited to be talking with you today on issues around evolving cannabis laws in hospital and healthcare education programs. Before we start, I'll cover a few housekeeping items. At the bottom of your audience console are a number of application icons for your use during the program today. I'll take a minute to highlight a few. If you have any questions during the webcast, please submit them via the question box. We'll try to answer any questions during the webinar today, but if we run out of time, we will do our best to answer later by email. We really appreciate audience participation and encourage you to submit any questions you might have. There's also an icon to assist with your viewing preferences. Please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or dragging it to the bottom right corner of the slide area. If you have any technical difficulty, please click the help icon. It has a question mark and it gives information on common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Illinois, Indiana, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Colorado and Wisconsin credit is pending. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, please click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with your certificate of attendance. Joining me today are Barb Grandjean and Ben Jones. Barb works in the Healthcare, Life Sciences, and Education Group as a partner with healthcare employers regarding workplace issues like hiring, discipline and termination, harassment, discrimination, privacy, social media, medical and non-medical leave, reductions in force, wage and hour matters, policies and training, and most importantly for us today, cannabis and drug testing. Ben's practice involves working with clients starting new businesses, particularly those in Colorado's budding cannabis industry. In addition to corporate matters, he works on employment agreements with clients and the labor and employment team, and thankfully for the education group, works with us on policies and procedures for clients, particularly around these cannabis laws. So with that, I will hand it over to Ben to give us an overview of evolving cannabis laws. Barb will talk about the practical implications for hospital and academic medical employers, and then I will touch on the implications for your institutions as institutions of higher learning. Ben, with that, I give it to you.
All right. Good morning, everyone, or good afternoon, depending on where you are. As Annie said, I'm a corporate attorney in our cannabis group in Denver, so I just want to give a quick overview of the state of cannabis laws in the country. Before getting into that, I just want to do some critical terms here. There's a big difference between marijuana and hemp in terms of legality, but not a big difference in terms of what they actually are. So marijuana, which is mostly what we're talking about today, is the cannabis sativa L plant and its products. Marijuana specifically produces a euphoric effect when ingested. That's really why people grow it. That's what they use it for. It's federally illegal, but legal in many states. Almost all the states actually have some form of marijuana legal, at least for treating medical conditions. Hemp, on the other hand, is the exact same plant. The main difference is that hemp, you can't get high from it. The DEA has said that if you ate or smoked enough hemp to get high, you would have a noticeable laxative effect from it. So be warned. And hemp is legal under the 2018 Farm Bill. A couple more critical terms. These are two of the main chemicals in the cannabis plant. THC is short for tetrahydrocannabinol. That's what gets you high. If you have more THC in a plant, it's marijuana. If you have less THC in a plant, that's hemp. And that is the sole difference between hemp plants and marijuana plants. CBD, on the other hand, is short for cannabidiol. CBD does not get you high. It does seem to have certain psychoactive effects. For example, there is an extremely effective seizure treatment that is FDA approved that is CBD. We don't really know a lot about it otherwise because medical research on marijuana and its products has been very restricted for a long time. But CBD can come from hemp as well as marijuana. It also has a very strong cultural presence. Right now it's at least a fad, if not a lasting thing. You'll see it on shelves in Walgreens, in CVS. I think every single coffee shop in Colorado has the option of pouring some into your coffee, which may not be effective. Keep that in mind. If you put it in a hot drink, it might not work. So now we'll move on to actual laws. Federal laws. Federal is easy. Marijuana is illegal. Just in general, everywhere. The Controlled Substances Act makes having marijuana, having THC, producing it, possessing it, and distributing it all illegal. In particular, the Department of Transportation, anyone who gets money from the Department of Transportation or works under their regulations has to have really rigorous drug testing programs, which makes sense. You don't want people driving while under the influence. But otherwise, like legal use under state law is really a low enforcement priority for federal prosecutors. And in fact, Congress has passed a law in every spending bill since 2013, I think, or maybe earlier than that, prohibiting the Department of Justice from using federal funds to disrupt state medical marijuana programs. So if everyone's in compliance with state law on the medical side, the Department of Justice is not allowed to go in and mess with that. Hemp, on the other hand, is legal, except where prohibited by state law. There's a few states where you can't have hemp or any hemp product. Idaho is one such state. But otherwise, hemp is legal everywhere. So this is a map of state laws. The darker ones have retail marijuana available, which is just anyone can go get it. Usually if you're, I think universally, if you're over 21, you can purchase marijuana. Otherwise, you treat it similar to alcohol, like minors cannot get it. You can get shut down if you sell it to a minor. Some of the other states have the darker green states have medical programs where people with a qualifying condition can get medical marijuana. And then the lighter green states have a medical program, but it tends to be restricted to either a low THC type of marijuana, so usually CBD is the active ingredient in there. You can't get high from it. But it should be noted that many, many, many states are moving closer and closer towards the retail side. And that's just been a trend that we've seen over the past decade. So now getting into employment laws, we sort of have three buckets for employment laws regarding marijuana use. The three buckets, the first one is that there's no provisions for employment protections in the marijuana statute or the constitutional amendment, however they made marijuana legal. The second bucket is the provisions directly in the statute or amendment that protects an employee's right to use marijuana off-duty. And the third bucket is wild cards, who would otherwise fit into one of the first two buckets, but have used some sort of other state law to either create a cause of action or say that there's no cause of action. So we'll start with bucket one. These states have no employment protection, and what you'll see is that Colorado's on that list, Washington's on that list. Those are two of the first states to allow for medical marijuana and retail marijuana. That tends to be sort of how these states started out. They didn't really think about what those issues might come up with the employment context of employees needing to use medical marijuana, but then going to work sometime after the effects wore off, but when they would still test positive. What you see, let's see. So we'll do an example of bucket one. So this is a case that came out of Colorado. It's one of the very first cases on drug testing for marijuana. This is called Coates versus Dish Network, LLC. The plaintiff in this case was Brandon Coates, who had no use of his limbs. He worked as a telephone operator for Dish Network. He would just pick up the phone when customers had a problem and help them through it. He took marijuana under Colorado's medical marijuana program. He never used it at work. He never showed up high, but Dish Network had a drug testing policy. They tested him. They obviously found him positive for medical marijuana, and then they fired him under their drug testing policy. Brandon brought a claim under Colorado's lawful activities statute, which protects employees' lawful off-duty activities. He did not bring it under the Colorado medical marijuana statute because, this is bucket one, there is no employment protection directly in the constitutional amendment where Colorado legalized medical marijuana. So the lawful off-duty activities statute just says if something is lawful, an employee can do it on their own time. If they don't show up to work impaired, then you can't fire them for it. This is sort of like alcohol. Like, you can drink alcohol off-duty all you want, just don't show up to work on it. The arguments in this case were, on Brandon's side, he was saying, we don't look at federal law for marijuana anyway. Like, everything that has to do with marijuana in Colorado is illegal under federal law. Why would we read federal law into the statute when we're talking about marijuana? And Dish Network's argument was essentially the opposite. It says, in order to be lawful, it has to be legal under both federal and state law. Otherwise, it is just illegal. And the Supreme Court of Colorado agreed with Dish Network. They said it does have to be federally legal. This isn't a situation that we come across very often, but there's nothing in the statute that says only state law. But they did make a point to say that if the law had been worded differently, or if the legislature had expressed some sort of intent upon passing this law that they wanted to limit lawful to state activity, they would have decided the other way. And so then we get to bucket two, where these states have more recent medical marijuana laws, and they looked at this Coates versus Dish Network, and they said, wow, if we want to protect employees' rights to use medical marijuana while off-duty, we need to put it right in the statute. So this is a list of states where that is the case. Then here's an example of one case out of Arizona where the protection was directly in the statute that said medical marijuana is legal. This lady, Carol Whitmire, was fired for testing positive for medical marijuana, even after she told her employer, Walmart, that she took a medical marijuana card. They actually made a copy of her medical marijuana card and then drug tested her, and lo and behold, she was positive for marijuana, and then they fired her. When the test came back, it was very high for marijuana metabolites. The manager who got the test results wrote down that this was a good faith belief that she was impaired that day, which happens to show up in the statute that if a test comes back really high from marijuana metabolites, that could lead to a good faith belief that they were impaired. Barb will talk more about this later, but that is scientifically untrue. A positive marijuana test result could mean that someone is impaired right then, or it could mean that they used marijuana sometime in the last 30 or 60 days. But anyway, after getting fired, she sued Walmart under the Arizona medical marijuana law, which prevents employers from taking action against employees for using medical marijuana off-duty. Her argument was that she was a qualifying patient, she wasn't impaired by her marijuana use while at work, and she was fired solely on the basis of a drug test. Walmart sort of bungled this a little bit. They initially said that she was fired just because she used marijuana. Then they backpedaled a little bit and said that they had a good faith belief based on that high metabolites drug test. But the court didn't really care either way. The court held that the Arizona Medical Marijuana Act protects employees from being fired solely on the basis of a test that came back positive. And in fact, this court granted summary judgment sua sponte to the plaintiff, which is essentially unheard of. So this is the kind of case that you really don't want to run into as an employer. If there is a protection in the statute, you don't want to have to be appealing things and then lose your court case at a very early stage decisively. And then bucket 3 is our wild cards, where there's judicial intervention that uses a different state law to protect medical marijuana use off-duty for an employee. And today, Massachusetts is the only state in this bucket, but tomorrow it could be literally anything from buckets 1 or 2. If there was no protection, a court could read protection into a different statute, or if there was protection, the court may decide that being federally illegal means that your employment is not protected. But it is much more likely to be that they read some protection in from another state statute, in particular, Rights to Privacy Act and disability statutes. So, an example of bucket 3 out of Massachusetts is this Barbuda versus Vantage Sales and Marketing. The plaintiff in this case, Christina Barbuda, lived with Crohn's disease and IBS. She treated those with medical marijuana, which was legal under state law. They increased her appetite and let her sleep. She applied for a job with Advantage, and she told them that she was taking medical marijuana at night, and she let them know that she would test positive for marijuana if they gave her a drug test. They went ahead and gave her a drug test. They hired her. She worked for one day, and then at the end of the day, she got a call from Advantage saying, your drug test came back positive, and they fired her. So she's understandably a little bit upset about this because they had told her that it was not a problem that she took medical marijuana, so she sued them. And in particular, she sued them under a state statute preventing disability discrimination. The arguments in this case were really that she was fired for treating a disability. She had Crohn's. She took medical marijuana to treat her Crohn's. And that was a reasonable accommodation. The employer should have accommodated her in having an exception to their zero-tolerance drug policy. And Advantage's arguments here were that marijuana is federally illegal, so it was per se an unreasonable accommodation for her disability. And the court ended up holding that the disability statute requires the employer to either accept a lawfully prescribed medication as an accommodation or engage with the employee in an interactive process regarding accommodations. In this case, they did neither of those things. So the employer had really failed to uphold its obligations under this law. The employer also, after engaging in this interactive process, if the employer does not want to give the accommodation, it's the burdens on them to show that there's an unreasonable hardship to this. And they weren't able to do that, and the court sort of opined that they probably would not be able to do that. There's no liability for an employer to have an employee who uses marijuana, except in a few circumstances where an employer is subject to particular federal laws, like those Department of Transportation testing requirements. Then we'll move on to Illinois, which has sort of a new approach. they fall into that second bucket where there is a provision directly in the statute protecting off-duty use. Illinois added medical marijuana to its Right to Privacy in the Workplace Act, or it added marijuana in general. The Right to Privacy in the Workplace Act just says that it gives employees a cause of action against employers for firing them for the lawful off-duty use of a lawful substance. The Illinois statute is unusual in that it protects retail use as well as medical use. Most provisions only protect medical use. So this is a little bit new. Maine actually also has a very similar law, but Illinois tends to be, it has more employers. This Illinois law was actually recently amended to allow for some pre-employment testing, which the previous version of the law did not allow. But there is still a requirement for an employer to have a reasonable, good faith belief that an employee is impaired at work, not just that they tested positive for a drug, but that they are actually impaired at work before they can be fired or disciplined. So that is sort of the lay of the land as it is right now. So I'm going to turn it over to Barb to talk about the practical implications of all these laws on employers.
Ben, thank you very much. And you didn't actually use as many puns in your presentation as you threatened to, so that makes me feel a little bit better.
You're welcome.
It's amazing to me listening to this presentation how it seems like just in a few short years, it's a lot easier to count the number of states that haven't legalized either recreational or medical marijuana than the ones that have. So it's a tidal wave that's coming for everyone. I also wanted to point out that I think we could do a separate hour-long webinar on the statutes and the case law developments in many of these states. But what I'm going to try to do for the next few minutes is give you a high-level summary of the types of things that employers and healthcare employers in particular should be thinking about with regard to marijuana. And what I want to start with is hearing from you all about some of your practices. And we're going to do that with a few poll questions. So the first poll question here is poll question number 1. Does your organization currently conduct pre-employment drug testing that includes marijuana? So if I can give you just a minute to answer that. Okay, excellent. So we have a majority of people that are doing pre-employment drug testing for marijuana, but we have a good number that actually aren't doing pre-employment testing, and that's the topic that I want to address once we finish with these poll questions, because I think it's something for everyone to be thinking about. Okay, poll question number 2. Does your organization currently conduct reasonable suspicion or post-accident testing that includes marijuana? So I'll give you just a minute to answer that. Again, a really similar split, actually, and that surprises me. I think I would have expected the yeses to be a little bit closer to unanimous, but that may also be a recognition that many of you understand the realities or the problems currently with testing for marijuana. The third poll question then, does your organization currently conduct random or periodic drug testing that includes marijuana? Okay, so this is also what I would have expected. Fewer employers are actually doing random or periodic testing. Sometimes that's something you might see in connection with a collective bargaining agreement, for example. But we still do have close to 50% that are conducting random or periodic drug testing that includes marijuana, which means that drug testing is going to reveal to you someone who has used at some point in the last 30 to 60 days approximately marijuana, and you won't know if it was at work or not. So the reason why I think this is important, it's really the fundamental problem right now with marijuana. Ideally, we would be dealing with marijuana in the workplace in the same way that we do with alcohol. We would observe that somebody appears to be impaired. We would send them for a test. The test would prove to us with some sort of scientific reliability that the person is presently drunk at work. But the fundamental problem with marijuana is that a positive drug test for THC is not the same as proof of impairment. Employers are always going to be able to take action as a result of actual impairment on the job, but it's hard to tell with marijuana. So as Ben had mentioned earlier, THC can remain in a user's body for weeks after consumption. It's a THC metabolite. And a urinalysis or a saliva test only detects those metabolites. It doesn't provide evidence of actual impairment. Blood tests are better, but they're still not perfect. And so, ideally what we're waiting for, I think, is a breathalyzer test. And it's not here yet. But at this point, any of the testing that you use isn't going to tell you reliably whether someone was impaired at the time the blood test was taken or the saliva or the urine, only that this person is a marijuana user of some kind. So it means that the most reliable way to determine whether somebody, or to assess whether you believe somebody is impaired with marijuana at work is the typical reasonable suspicion. So you're looking at physical signs of impairment, things like slurred speech, bloodshot eyes, or an odor. But even then, that's not a slam dunk. So I'd like to frame the discussion, and my question for you to think about is, for those of you who are doing comprehensive drug testing that includes marijuana, and I mean there something like a pre-employment or a random testing, so those are things other than when you have a reasonable suspicion that someone's impaired at work, I'd like you to ask yourself why you're doing that kind of testing. Most employers aren't obligated to conduct drug testing. And there are exceptions to this, and Ben mentioned, the Department of Transportation being a main one. They are affirmatively requiring people that they regulate, employers they regulate, to affirmatively test for drugs and alcohol. But many of the organizations listening to this webinar may be regulated by something like the Federal Drug-Free Workplace Act. And that act requires federal grant recipients to adopt and maintain a zero-tolerance policy, and it permits, but it doesn't require employers to conduct mandatory drug tests. It does prohibit use or possession in the workplace. Also, I suspect there are employers on this webinar that participate in Medicare or Medicaid, and they agree to comply with federal and state laws. But in this context, again, federal law does not require drug testing of employees. It would certainly very likely be a violation of the federal law if someone was using or possessing in the workplace. And I'd like to direct your attention to the case of Nofsinger versus SSC Niantic Operating Company, which is just a DBA for Bridebrook Health and Rehabilitation Center. This was a district court federal case in Connecticut from September of 2018. And in this case, the plaintiff was qualified under the state's medical marijuana statute for her PTSD, and she received an offer of employment from Bridebrook to be their activities manager. Her offer was conditioned on a pre-employment drug test, and she, at that point, disclosed that she was a medical marijuana user. She participated in the drug screen. Her sample came back positive for THC. Bridebrook rescinded her offer, and as you might expect, litigation ensued. You're going to recall that Connecticut was one of the bucket 2 states that Ben talked about, so it has an anti-discrimination provision built into its statute. And it also has an exception to the anti-discrimination provision that says the discrimination is essentially okay if it's required by federal law or required to obtain federal funding. So naturally, one of the defenses that Bridebrook raised was that the Federal Drug-Free Workplace Act barred it from hiring the plaintiff because the facility's substance abuse policy was adopted for the express purpose of complying with the Drug-Free Workplace Act. But the court, in this case, disagreed, holding that the Drug-Free Workplace Act doesn't actually require any drug testing. The court said, quote, that defendant has chosen to utilize a zero-tolerance drug testing policy in order to maintain a drug-free work environment does not mean that this policy was actually required by federal law or required to obtain federal funding. Brydebrook also made an argument that many of the organizations on this call might make. They argued that the False Claims Act was a defense, alleging that if they had employed someone who used medical marijuana in violation of federal law, it would amount essentially to defrauding the federal government. The court again rejected the argument, and this time it said, quote, because there is no federal law that bars defendant from hiring plaintiff on account of her medicinal use of marijuana outside of work hours, it would not constitute fraud on the federal government for defendant to hire plaintiff. So this decision, I think, really, it's not binding unless perhaps you're in Connecticut, but this decision, I think, gives employers and healthcare employers some food for thought about why they are actually conducting pre-employment testing of their employees or anything other than a reasonable suspicion testing. So let's talk for a minute about the different times that you might be conducting drug testing for marijuana and the legal implications. So I have my stoplight analogy here, and my first category is the green light. Reasonable suspicion drug testing and drug testing post-accident, which is a subset essentially of that, gets a green light in every state. That's essentially just like alcohol. The issue being that we can't confirm it positively with a drug test, but if you have a reasonable suspicion that somebody is actually impaired at work, you're going to be in a better position to take action. And that kind of testing is appropriate in every state. This type of testing is also incentivized under a variety of state laws. Employers can get reductions in their workers' compensation premiums, reductions in workers' compensation damage payments, and also unemployment benefits, denial of unemployment if drug testing reveals a present impairment, coupled, again, in the marijuana situation with a reasonable suspicion of impairment. The key to reducing the risk associated with this kind of testing is to make sure that it really is reasonable. So under Illinois' new law, for example, there is a specific safe harbor for employers who have a good faith belief that an employee was impaired or under the influence while at work. And so the best protection or the best way to reduce risk for these green light tests is the old HR mantra of document, document, document. Make sure that you're very clear about why you have a reasonable suspicion or a good faith belief that somebody is presently impaired. And we'll talk a little bit later about some of the training that you might do on that. My next category are the yellow light types of testing. And this is where I've put pre-employment testing. I've also put random or periodic and last chance or return to work. It's my prediction that pre-employment testing that includes marijuana in most industries, including much of healthcare, is going to start to disappear. And that's for both legal and practical reasons. So as I've mentioned, the pre-employment drug test by definition isn't based on any reasonable suspicion that somebody's presently impaired. And it's also, by definition, testing for conduct that's occurred outside of the workplace because that applicant has never actually worked for you. Legally, we're starting to see some jurisdictions outlaw pre-employment testing for marijuana. And so in just a couple of weeks, in January 1st of 2020, an employer in Nevada, it will be unlawful to reject a job applicant who tests positive for marijuana on a pre-employment basis. New York City has also passed a similar law, and I think we're going to see more and more of these. Now, the Nevada law does have an exception. So a pre-employment test that tests positive for marijuana is something an employer can rely on if it's a public safety worker or someone has a driving job. There are also exceptions to that pre-employment testing prohibition for positions that the employer determines could adversely affect the safety of others. As Ben mentioned, prior to the December 2nd amendment of the Illinois law, Illinois employers also would have faced liability for rescinding a job offer based on the lawful use of off-duty products. But the amendment that was recently passed effectively reduces that risk for Illinois employers, so that's good news. I think it's entirely possible that for the healthcare employers on this call, the safety-related exceptions to the pre-employment testing issues are likely to be applicable. So again, back to Nevada, if you're a healthcare employer in Nevada, you may very well be able to argue that pre-employment testing for marijuana, if not done, could adversely affect the safety of others. But I would encourage you to think about whether that's actually true for your entire workforce, or whether there are really just select positions that are safety-related or safety-sensitive positions, and that those are the only ones that you should take the risk of doing the pre-employment screening on. Because for everybody else, it's better, it's kind of a don't ask, don't tell. You don't want to know if they test positive for marijuana unless you have a reasonable suspicion that they're presently impaired. The other reason that I raise this issue is something that we're seeing increasingly in Colorado, and it's the practical reason why employers are very likely going to have to stop pre-employment testing. And I would guess that it may be why some of you who answered that poll question that you're not doing pre-employment testing to include marijuana answered it that way. And that's just for economic reasons. When the labor market gets tight, it's extremely difficult to fill positions, and if we're excluding individuals who are using cannabis outside of work, if we're excluding them from consideration, particularly for jobs that aren't in any way safety sensitive, we're reducing the pool of workers, and we're not going to be able to fill our positions. What we see here, I think in Colorado being one of the first states to have legalized, is it's become so mainstream that a lot of people are using some kind of marijuana product when they're not at work. And I included the random or periodic and the last chance on this slide because similarly, I think those are types of testing that as you're looking at your particular state law and the developments in this area, also types of testing that aren't really based on any kind of a reasonable suspicion. And so it's possible that they are going to become problematic for you. Again, back to Illinois prior to the amendment, I think something like a last chance or return to work type of test probably would have violated the Illinois statute as originally passed. So then I have to finish my stoplight analogy with a red light, otherwise it doesn't work. And I couldn't really come up with anything that is an absolute prohibition when it comes to drug testing on marijuana across the board. But I thought this was just a good chance to remind you all of some of the risks associated generally with drug testing if it's not done correctly. You want to make sure that whatever drug testing you're doing is being done by categories of employees, types of jobs, safety-sensitive jobs. Avoid stereotypes, avoid one-off testing, avoid testing that's only implemented for people of a certain age, national origin, et cetera. Remember that if you're not following your drug testing policy, there are other types of legal claims that can come at you from your employees, claims that we don't see as much anymore, but claims for invasion of privacy, depending on how you're conducting the tests and how privately you're doing it, defamation, if there's a risk of publication of false drug results. And then for this group of people on this call, I'm assuming that many of you are covered entities under HIPAA. And so if you are treating job applicants or employees as patients, you're doing the drug testing in-house, then remember that those drug testing results are treated as PHI, so they're protected under HIPAA. So the question is, once you have conducted drug testing and learned someone's using marijuana, or once someone has disclosed that to you, what do you do with the results? And this is a tricky question when someone has disclosed that it's because of an underlying disability and they have a medical marijuana card. So as a federal matter, employers are not required to accommodate marijuana use under federal law. The applicable federal law is the Americans with Disabilities Act. And Section 12114A of the ADA specifically states that a qualified individual with a disability shall not include any employee currently engaging in the illegal use of drugs. We haven't seen any EEOC guidance on this, whether they would like to take issue with this from a disability perspective. But the assumption at this point remains that as long as marijuana is federally illegal, the federal ADA isn't going to require accommodation of use, even if it's related to an underlying disability. The scenario when it relates to state laws, though, is a completely different thing. So as Ben discussed earlier, at the state level, the employment protections that are available to someone who uses medical marijuana are generally tied to the bucket that your state falls into at any given time. And I wanted to point out there's another case, if you have some spare time and want to do some reading. At the end of November, the Court of Common Pleas of Lackawanna County, which is a state court in Pennsylvania, issued an order on a demurrer, which I understand is the equivalent of a motion to dismiss here in Colorado. And the defendants in that case were a hospital and a health system. It was the Moses Taylor Hospital. The case is number 19CV1315, and I'm recommending it for reading if you're interested in these topics about employee protections. It's a 51-page order. And in that order, the court goes through and summarizes much of the recent case law in this area, some of the things that Ben talked about, some of the different rationale for implying causes of action into the marijuana statutes or otherwise to protect employees. The punchline of that case is that in Pennsylvania, the Pennsylvania Medical Marijuana Act, it confirms that Pennsylvania is in fact one of those bucket 2 cases where there's express protection that's been read into the statute with a private cause of action for an employee. And we can either, I guess I'm happy to send you a copy of that opinion if you have any trouble locating it. It's not a published opinion at that point. So from the disability perspective, my recommendation is that no matter what state you're in or what bucket you're in, it still is a best practice to engage in an interactive dialogue with an employee who indicates that the reason for a positive test is a medical marijuana use for an underlying disability. It never hurts to have that conversation, and I think it's important in this area in particular to be creative. When you're thinking about how you can accommodate somebody who is using medical marijuana, is it, like in Massachusetts, an exception or an accommodation, a change to the zero tolerance policy, or can you do something like allowing the employee to work a modified schedule to allow them to treat their medical condition at home during working hours using medical marijuana, for example. But I think the takeaway here is that no matter which bucket you're in, employers are not required to allow on-site use of marijuana or impairment, and workplace safety is always going to carry the day for a valid justification for any decision that you make. So a few takeaway recommendations from a high-level employment perspective when it comes to marijuana. Be familiar with your state law, and as well as any lawful off-duty use laws and disability discrimination laws. Know which bucket you're in. Be conscious of Ben's point that at any time you could fall into bucket number 3 along with Massachusetts, where a court decides they want to find some way to protect that employee, and if it's not under the marijuana law, it may be under some kind of privacy or disability law. Know your obligations. So are you a Drug-Free Workplace Act obligated employer? Is there something else that is requiring you to do any particular kind of testing? So you have to ensure that you're following any federal compliance requirements. And I challenged you earlier to think about why you're doing pre-employment testing or random testing for marijuana. But I want to be clear, I'm not advising you to stop doing it if you're able to identify some obligation that requires you to be doing pre-employment testing. I think that oftentimes employers just assume that they have to, but I challenge you to explore what regulates you and your business. Consider whether you have employees in safety-sensitive positions. As I mentioned earlier, safety is always a reason to test and take action, but I would bet that there aren't many employers on this call who have every single employee that works for them in a safety-sensitive position. So there's nothing wrong with saying that you're only going to do certain kinds of drug testing in certain types of positions because they happen to be safety-sensitive. Think about whether you have a collective bargaining agreement or some other source of regulation that relates to what you're doing with drug testing. We're recommending, obviously, that you are updating your policies. Make sure you're focusing on on-site possession or impairment. Treat marijuana like alcohol in your policies to the greatest extent possible. Focus on clear performance expectations more so than the underlying conduct. As long as somebody is getting the work performed, does it really matter to you how they get there? Focus, I think this is an important one. As you're looking at your policies, if you haven't revised them recently, you really need to focus on the practical realities of regulating marijuana in today's society, and it's marijuana and its relatives. So Ben mentioned CBD earlier on. CBD does not get you high, but CBD is ubiquitous. It is everywhere. And so are you prepared to take action against your employee who brings her CBD hand cream into the office? What does your policy say about CBD, and are you prepared to regulate it, and do you need to? Now, an example here of an issue is for an employer in Iowa, where Iowa still, as a matter of state law, CBD is not legal. Also then make sure that in each state that you're in, that your policy is updated to reflect the subtleties of your particular state law. Another example from Illinois on that one, Illinois defines on-call in the marijuana statute as someone who's on duty for purposes of not using, but on-call status is defined as requiring at least 24 hours notice. And so if your on-call definition is different than that, you're going to want to adjust your drug policy accordingly. Train your managers. I definitely don't want to skip that one. If you're not regularly, I did skip it again though. There. You need to be having regular training with your managers because, as we all know, these kinds of reasonable suspicion and drug issues are going to come up when HR has gone home for the night, and so your managers need to know what to do. I think a key area in the marijuana space, now that we're talking about reasonable suspicion and good faith exemptions, is that you need to train your managers on how to objectively identify reasonable suspicion. You don't want to be in a situation where you're facing discrimination claims because different managers have different definitions of reasonable suspicion or impairment. You also want to make sure that you're training your managers on the indicia of marijuana impairment specifically. So make sure that your current training and your checklists and whatever else that you have are actually giving people the right things to look for with marijuana. You also want to make sure your managers have consistent documentation about the good faith belief. So again, we want to avoid inconsistencies and possible discrimination claims. And your managers also need to understand and be refreshed on your testing policies. All right. Finally, then, make sure your employees know your policies. That's something that we run into quite a bit here in Colorado. If your policy only refers to an illegal drug and doesn't specifically call out marijuana as being one of the prohibited substances, I can guarantee that your employees are going to assume that marijuana is legal and therefore excluded from your definition of illegal drugs. They're not thinking about the federal-state dichotomy. And then finally, make sure what your employees know what your policies are with regard to things like CBD, paraphernalia as it may be used in the marijuana context, marijuana in all of its forms, not just smoking, but edibles, drinks, etc. And these are all things that our workforce today generally assumes are okay. And so if they're not okay in your workplace, you need to be very specific about it. And with that, then, I will turn it over to Annie, because I know many of you listening today have healthcare education programs, and Annie's up next to tell you what you need to know.
Thank you, Barb, and thank you, Ben, for those great presentations on an overview of the law and issues specific to employers. As Barb mentioned, a lot of you are healthcare educators as well, and not surprisingly, these evolving cannabis laws apply to higher education situations. They create a lot of similar issues. So first up is a poll question. What issues arise for institutions of higher education around the legalization of cannabis at a state level? Is it about funding obligations? Is it about relationships with clinical sites, pathways to developing cannabis programs, or is it all of the above? I'm really expecting 100% of you to get this correct, and we'll see what the answer is in just a minute. As soon as we can manage to push it to the audience. We're having a little bit of technical difficulty. But since we're having technical difficulty, I think you do all know the answer, and it is all of the above. Education law layered on top of your healthcare laws and your employer considerations includes some unique obligations around cannabis and legalization. Almost all institutions of higher education participate in federal student aid programs under Title IV of the Higher Education Act. We'll unpack some of the requirements that come along with that on our next slide. Many members of the audience participate in other funding programs like NIH, NSA, Department of Defense grants that have restrictions around tolerating drug use, like the Drug-Free Workplace Act that Barb mentioned. And as federal fund recipients, you have to comply with disability laws, fair housing laws, Department of Transportation regulations. You also need to use care that if you choose to somehow participate in the cannabis industry through programming, that you align any of your activities with restrictions on advertising limits under the Controlled Substances Act or limits on accepting funds from those involved in the marijuana industry. And if you're allowing some of those activities to take place, if any of your stakeholders who are involved are international students or international employees, they may have another layer of restriction around their participation in those activities. If you're a public institution, keep in mind that even though you may not need to tolerate illegal drug use in certain circumstances, you absolutely must not discriminate based on viewpoint against individuals or groups who are advocating for drug-related or drug use causes. And of course, you need to comply with state and local laws, which can be even more challenging if you're an institution with campuses across the country, as many of you are. Looking to Title IV federal student aid, for those of you who aren't directly involved in education, or maybe those who are, who haven't noticed, federal student aid really is the lifeblood of almost all degree programs in the United States. And their program participation agreements are the contracts that they have with the Department of Education that set the conditions for their participation in federal student aid programs. Those are programs like Pell Grant programs, direct loan programs, federal work study. And those program participation agreements require that each institution have a drug and alcohol abuse prevention program that includes an annually distributed policy in writing applying to all students and to all employees that prohibits illegal possession, use, or distribution on your property of controlled substances or as part of your programs and activities. And this policy has to say that you will discipline those who violate it. Similarly, as with purely healthcare institutions, the program participation agreement requires compliance with the Drug-Free Workplace Act, and presumably your program participation agreement, by requiring a policy, is requiring more than a piece of paper. They're requiring that you actually enforce it as written. As a side note, there is legislation pending to end this, in part because of racial disparities in conviction rates and these evolving state laws that we're talking about. But at the moment, students who are convicted of drug offenses will have their aid eligibility suspended for various amounts of time, depending on how often they're convicted or what they are convicted of. And state laws legalizing marijuana don't obviate the need for you to report drug policy violations and arrests as part of your annual security reports. All of those are tied to your federal student aid participation, and even as our state laws are changing, unless or until the federal laws change, taking risks in this area involve risks around your federal student aid participation. And in addition to those federal funding requirements, In healthcare education programs, these changing laws can impact and present really difficult practical issues around your clinical programs. In most cases, you have clinical student placements where your students are getting credit or making progress towards their degrees, and those are considered part of your educational programs and activities even if they're occurring off of your property. So institutions need to use a lot of care to make sure they're addressing policies appropriately with the clinical sites. If possible, align your policies with those of the clinical sites. As Barb mentioned, consider whether your zero-tolerance policies, and I know that many of you have them, are necessary. At least, are they necessary around testing for marijuana? Do you have to be doing testing? Is there some sort of licensure requirement or regulatory requirement that's mandating you do that? At least ensure that your affiliation agreements with your clinical sites specify whose policies apply to your learners, where and when they apply. You may not need to go as specific as the cannabis level, but consider whether your policy should do that in light of confusion and changing laws at the state level. And absolutely make it clear, not just to your faculty and staff, as Barb suggested, but also to your students, which policies are going to apply. We have seen at least 3 lawsuits filed by students who failed drug tests because of state-authorized medical marijuana use, and they were expelled or they weren't allowed to complete their clinical programs. At least one court in Connecticut, Connecticut seems to be very pro-accommodating disabilities through the use of medical marijuana and not having negative consequences there. At least one court issued a TRO preventing a student from being expelled on the basis of a negative drug test. In each of these cases, some school official told the student, either a disability services officer or an instructor who wasn't informed, that medical use of cannabis would not impact the student's ability to complete their programs. And of course, when it got up to higher level administrators or hopefully general counsel's office, the student was informed otherwise. We haven't seen cases around recreational use just yet. That's probably because states tend to limit marijuana use to those over 21, and for many of our colleges and universities that eliminates a large chunk of your student population, although not all of them. But also courts who have considered institutional policies around alcohol, even for those over 21, have found that schools have a right to control or have policies about alcohol abuse on their campus, and that's probably why we haven't seen the cases about recreational marijuana use on campus. Also, for these healthcare clinical programs, keep in mind that not only are you balancing clinical site requirements and your federal student aid requirements, you're also balancing some licensing requirements for many of your programs. Even if institutions end up in a position where they can't discipline someone for a positive drug test, you may still need to report that, or if you are a healthcare provider with a student at your clinical site, you may need to report that to a state nursing board or to a medical board. These boards have in the past, this may be changing, but they have routinely taken disciplinary action against people with negative drug tests, even if the drugs were legal in the jurisdiction where they were consumed. So even if you adjust your policy to allow off-site use of cannabis outside of your programs, consider whether a licensing board would discipline or deny licensure to your students. And if that is the case, make sure you are communicating very clearly with your students about what off-campus use would mean for them. You don't want them to get through their educational program and find out that they cannot qualify for the profession for which they have been preparing. What should you do if you have a student claiming the need to use medical marijuana as a disability accommodation on campus? Again, as Barb mentioned, interpreting the ADA, courts have found that you don't have to allow illegal activity as an accommodation. We haven't seen education law or guidance in this area yet, so I would suggest that you consider and look to the guidance that Barb offered, as courts often look to discrimination situations in employment when there isn't corollary education case law available. Housing can be one of the most challenging aspects of marijuana laws for your institutions of higher education. Unlike employers, a lot of colleges and universities are landlords to your students, or at least you have temporary landlords who are housing residents or interns sleeping at your hospitals. It's arguably considerably easier for an employee to go off-site and engage in medical marijuana use off-duty than it is for learners who are living on your property to do that. And with regard to housing, some states have implied that landlords have to permit medical marijuana usage. So as you are parsing through your policies, consider housing as well and consider what your state laws say with respect to that and the risks you're willing to take. Regardless of those ambiguities around disability accommodation, you always have an obligation under the ADA and Section 504 of the Rehabilitation Act to engage in a case-by-case disability accommodation analysis for your students. So don't have a bright line rule that says if you use medical marijuana, you're out of the program or you will be disciplined. Depending on your students' individual needs, you might be able to accommodate them in some way, like allowing exceptions to drug testing policies for off-campus use, classroom telecommuting, or even alternative clinical placements. You may be able to find a clinical site that would allow off-duty use. So hold true to those disability accommodation policies by shepherding students through that accommodation process, regardless of whether you are going to allow medical marijuana or other negative testing in your programs and activities. We get a fair number of questions around taking donations from the cannabis industry, thanks in part to our cannabis lawyers in Denver, and questions about research on medical marijuana. Under current Federal Reserve Bank guidance, accepting funds from the marijuana industry can implicate federal banking rules. It can also implicate money laundering and aiding and abetting laws. Activities like accepting those donations directly from industry or conducting research that would promote the cannabis industry could run afoul of those laws. So, although the practical risks of getting prosecuted for this may be pretty low, a lot of institutions have policies that prohibit philanthropic or research funding from the industry directly, and several of those institutions that prohibit it do allow for donations or funding from individuals, provided there's not kind of a bright line, direct line back to the industry. In terms of internships and consulting, we get the question of whether students should be allowed to engage in internships in the cannabis industry or whether faculty and staff should be allowed to act as consultants for the industry. This could be considered an institutional activity depending on the facts and circumstances, depending on how involved the institution is in administering a fellowship or administering consulting work. If it's not federally legal, in other words, if we're not working with situations where you have FDA or DEA approvals, there are obvious risks involved. There could be risk to funding sources, especially if the work is perceived as being done on behalf of your institution, and risk that advising institutions could run afoul of those aiding and abetting laws. So at a minimum, I will suggest that you prohibit using institutional resources, facilities, or funds in this sort of work. And to the extent you are allowing employees to participate in consulting, require that they make it crystal clear that they are not doing it on behalf of your institution. And carefully consider whether you want to accept the risk of placing students into internships or fellowships that are involved with cannabis or with the cannabis industry. Occasionally we will get questions about cannabis programs. It's certainly a hot topic. It's super appealing to curious students, to faculty members and administrators who are interested in innovation and in growing enrollments. They might start to see chemistry, pharmacy, business programs that are supporting employment for students in the future in the cannabis industry. And surprisingly enough, sometimes these excited faculty members and administrators forget to involve counsel before they go ahead and do that. We suggest that you take steps to make sure that doesn't happen. There are lots of examples of programs that have started where clearly counsel has been advised ahead of time and has participated. As an example, a new California law lets the University of California, San Diego do it. They are approaching it very carefully, and we suggest you recommend the same to your constituents. The bottom line is these state laws are going to continue to change. They do have some restrictions in them, like the Illinois law, age restrictions or growing restrictions, and we will continue to have disability accommodation issues outstanding until we get some additional guidance. It's certainly high time for that. There's no doubt that we're going to keep seeing changes, and we will continue to monitor them. It's challenging to write perfect policies. It's always challenging to do that in a new frontier. But go ahead and start making reasonable attempts. Calendar every few months to look back at your policies and make sure they're working for you as a practical matter, and tell those employees, tell those learners exactly what is expected of them, and invite feedback as you go forward so you can practically ensure compliance going forward. With that, I see that we are out of time. We have a couple of questions, and we will do our best to answer those offline. Thank you so much for participating today. We encourage your feedback on the survey link at the bottom of your screen. Your feedback helps us in providing engaging and quality programs in the future. As a reminder, this program has been approved for Illinois, Indiana, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Colorado and Wisconsin credit is pending. A recording of the website will be available tomorrow for watching and sharing, and once available, a link with it and your certificate of attendance will be sent to you. Thanks again for participating. This concludes our webinar.